Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. As always, this is a show designed to answer your legal questions, and I will be with you for the duration of the next hour. Feel free to participate in the show either by calling the landline telephone number that you see at the bottom of your screen and speaking to me live in the studio with your question and to receive your answer. Alternatively, if you wish to participate but not to do so live on air, then feel free to send your question through on the mobile telephone number, which again you see at the bottom of your screen, and that's a WhatsApp message. With your questions, please ensure you provide sufficient detail for me to understand the nature of your query so that I can provide you with the fullest of answers. And as I remind our viewers on a weekly basis, the questions need to relate to English and Welsh law. That is the jurisdiction that I practice in, and that's the jurisdiction I am familiar with. If your question relates to a different jurisdiction, then unfortunately I may not be in a position to give you any advice. I may be able to signpost you to other services that are available, but not actually give you guidance in respect of your inquiry. I can deal with a whole host of things, so your question may relate to employment law, it may relate to family law, it may also relate to immigration law or criminal law. So feel free to send your questions through and, as I say, provide as much detail as you are able to do so. We do receive quite a high volume of questions and queries, so please ensure that you get your question in as early as possible so that you do receive your answer in today's show. If you do not receive the answer today, then I will save that for the show next week. Alternatively, you may want to tune into the Legal Advice Clinic tomorrow with our colleague, Mr. Bulbulia, and present your question to him. I do have a number of questions already, some from previous weeks and some that have come through today. Before I do turn to those questions, however, I want to present some legal updates, and I know our viewers receive these well, and it's always good to understand what the legal position is. The two updates that I wish to speak about today relate to UK immigration law, and many of you know that there have been significant changes in recent weeks and recent months with regards to immigration law and provision. The one I wish to touch on today is, unlike most updates from the Home Office, is a welcome change, and a change that will make a material difference to many lives in this country. And it relates specifically to British citizenship applications and citizenship applications from children. Our viewers will be aware, and those of you who have tried to register children as British citizens will be aware that the fees are quite extortionate. £1,012 per child, plus £80 if that child then turns over turns 18 or over before the decision is actually made, and that's for the citizenship ceremony. And that meant that many families and many children were priced out of being able to register as British citizens. And the Home Office has agreed on the back of legal action, but has agreed to review the position with fees and children, and agreed to devise a policy which would reflect the best interest of children as the government and the authorities are required to reflect. So with regards to this new policy, it comes into force on the 16th of June. So we are a couple of weeks away from the effect being felt. But the policy relates to fee waiver applications for children citizen registration. And what that means is that if you are a family who has a child or has children who are eligible to register as British citizens, but find that the extortionate fees are preventing you from doing so, then you may apply for a fee waiver in respect of those fees. And it pretty much in line with other fee waiver policies in place currently, the Home Office will consider the financial circumstances of the family, the child and those who can reasonably be expected to pay on behalf of the child. So that would usually be parents or guardians or other adults involved with that child who have financial responsibility for them. And the Home Office will then assess the income and any assets, and it will make an assessment as to whether or not these fees are affordable. Now, bearing in mind that the fee is being asked to be waived, the Home Office will carry out a thorough assessment of the income, and it will look at things like the level of spending within the household, for instance. So is the level extortionate or disproportionate even compared to the income? So if you have, for example, a lavish and luxury lifestyle, the Home Office may reasonably expect you then to cut back and save for the fees, and that would be proportionate in the circumstances. If, however, like many of us at the moment, you are you have an income or you have money coming into the household, but you are simply getting by, you're able to afford your utilities, you're able to pay your rent or mortgage, you're able to buy the weekly food and clothe the children and so forth, but don't have sufficient funds left over to then save for these fees and to pay for your children to be registered or your child to be registered, then the Home Office is more likely to grant you a fee waiver in regards to those applications. So that as I say, is a welcome move. 16th of June is when that policy comes into effect. So any applications made on or after that date will be able to benefit from those provisions. So do take advantage of that. Another rule, and we have touched upon this, so there are further rule changes, and you will remember from a show I did in March with regards to the changes to the family life and private life routes and the policy in respect of that. And many of you will remember that I explained that children who were born in the United Kingdom and have therefore then have thereafter resided in the United Kingdom for a period of 7 years will be entitled to apply for indefinite leave to remain upon reaching that age of 7 years. At the moment, that policy is that a child who achieves the age of 7 years and it is unreasonable to remove them from the United Kingdom can apply to regularise their status, but they would go on to the 10-year route to settlement. As I say, again, a welcome change there. If the child has now been in the United Kingdom for 7 years and they were born in the United Kingdom, then they can apply for indefinite leave to remain from the outset. If a child wasn't born in the United Kingdom but has resided here for 7 years, then the policy will state that they can apply for limited leave, but it would be on the 5-year route to settlement. And there are provisions to either apply for 2.5 years or the full 5 years at the outset. So the 30 months or the 60 months at this outset of that application. And it's the 20th of June for that policy to come into force. So again, if you have children who were born in the UK and can benefit from that, then that's something else that you need to look into and inquire about, because then those children have the stability and certainty for their future as settled citizens in this country or settled individuals in this country. I believe we do have a caller on the line, and I will proceed to take that call. Hello, assalamu alaikum. Hello, assalamu alaikum.
वालेकुम सलाम जी। तो मुझे ये पूछना था, ये जो मेरा लड़का है होमलेस में है 5 साल से।
अच्छा।
तो उन लोग ने बीडिंग नंबर अभी तक दिया नहीं है, तो क्या कर सकते हैं उसके लिए?
सॉरी, क्या नहीं दिया उन्होंने आपको?
वो बीडिंग नंबर बोलते हैं, जो बीड करते हैं हाउस का, जो बीडिंग नंबर।
जी।
हाँ, तो वो दिया नहीं है।
और 5 साल से वो इंतजार कर रहे हैं?
हाँ, 5 साल से वो हॉस्टल में है।
अच्छा
जी।
तो उन्होंने ये जो नंबर उन्हें चाहिए, उन्होंने उसकी रिक्वेस्ट की है काउंसिल से, या वो क्या कहते हैं?
हैकिंग काउंसिल है। जी
सॉरी कौन सी काउंसिल है?
हैकनी काउंसिल है
हैकनी काउंसिल जी। और काउंसिल ने क्या कहा, वो क्यों नहीं नंबर दे रहे हैं?
कुछ नहीं, अभी तक कुछ दिया नहीं है उन लोग का।
ओके सो अगर आपको काउंसिल से शिकायत है और अगर ऑब्वियसली वो नंबर नहीं दे रहे हैं तो आप कोई शिकायत कर सकते हैं, तो आप उनसे उनकी जो कंप्लेंट्स पॉलिसी है वो मांगे कि आपकी
क्या बोलते हैं जब भी फोन करते हैं तो वो कंप्यूटर वायरस है, तो अभी तक ऐसा ही बोलते रहते हैं। अभी जब इन लोग का पैसा जब चढ़ जाता है, जब फोन आ जाता है
जी
तो वो कैसे पता चलता है उन लोग को कि ये पैसा रेंट का थोड़ा बढ़ गया, 6 पाउंड बनना है हर हफ्ते।
अच्छा ओके तो आप ऐसा करें कि आप उनसे अगर वो कंप्लेंट्स पॉलिसी उनको देनी होती है, कानूनी उनको वो आपको देनी होती है, तो उनकी कंप्लेंट्स पॉलिसी लें और उनको लेटर लिखें, कंप्लेंट का लेटर लिखें कि आपकी उनसे शिकायत क्या है। अगर वो उसे रिजॉल्व नहीं करते हैं या आप उनकी कंप्लेंट्स पॉलिसी आप उनको वो नहीं दे रहे हैं और आप उनकी वेबसाइट से नहीं ले सकते, तो जो काउंसिल होती है लोकल अथॉरिटी ओम्बड्समैन होते हैं, वो एक सेपरेट इदारा होता है, इंडिपेंडेंट होते हैं काउंसिल से। आप उनसे कंप्लेन कर सकते हैं कि हमारे पास हमें ये प्रॉब्लम्स पेश आ रहे हैं और ये रिजॉल्व नहीं कर रहे, और फिर वो इदारा जो है वो आपकी कंप्लेंट देखकर वो आगे आपकी मदद कर सकते हैं।
कौन सी अथॉरिटी जो हैकनिंग काउंसिल की जो
लोकल अथॉरिटी ओम्बड्समैन उन्हें कहते हैं। ओम्बड्समैन जी
जी जी
ओके तो आप अगर पहले काउंसिल से रब्ता करें, क्योंकि राइटिंग में आपने कंप्लेंट डालनी है। अगर वो उससे रिजॉल्व नहीं करते हैं तो फिर आप ओम्बड्समैन के पास जा सकते हैं कि हम कंप्लेंट डाल रहे हैं, वो इसे रिजॉल्व नहीं कर रहे हैं, वो कंप्लेंट्स पॉलिसी नहीं प्रोवाइड कर रहे हैं, तो आगे फिर ओम्बड्समैन जो है वो आपको गाइड कर सकते हैं। इसके अलावा अगर आपको मदद चाहिए तो आप सिटीजन्स एडवाइस ब्यूरो से भी बात कर सकते हैं, वो शायद आपके लिए ये कंप्लेंट्स पॉलिसी हासिल कर सकें। और अगर आपको मदद चाहिए कंप्लेंट्स लिखने में ओम्बड्समैन के पास जाने में, तो वो पूरी आपकी मदद कर सकते हैं।
जी बहुत ट्राई किया हमने।
ओके अब सॉरी मेरे भाई, हम ब्रेक के लिए जा रहे हैं, तो इंशाल्लाह ब्रेक के बाद हम वापस आते हैं। शुक्रिया, अस्सलाम वालेकुम। Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Just before we went to that break, I took a question from one of our viewers who called in relation to a housing matter. With regards to the query, the caller has a son who is housed in a homeless hostel and is waiting for more permanent accommodation, but the council is not providing the relevant assistance. He has been there for several years now, and the query was in regards to what their options are. They have tried to get through to the council and have been moved away and fobbed off essentially by remarks such as there's a virus in the system and we can't give you any further clarity at this moment in time. My advice was to access the complaints policy. Every company and authority is required to have one. You usually find these on their websites, but you can also request one from the organisation that you are dealing with. And what you can then do is follow the complaints policy. Usually it requires you to put the complaint in writing, and then there are timescales set out within that complaints policy as to how and when the company will deal with the complaint. Our caller unfortunately had problems obtaining that as well. And so the advice was twofold. Firstly, seek assistance from the Citizens Advice Bureau. They can help with requesting a copy of the complaints policy, but also drafting the complaint. And then the second part of the advice was that failing all of that, there is a local authority ombudsman who is independent and can address complaints of this nature as well. And so the advice was to access that service if need be. We do have another caller on the line, so inshallah we'll proceed to take that call. Hello, assalamu alaikum. Hello, assalamu alaikum. Assalamu alaikum, you're through. Hello?
Yeah, can you hear?
I can now, yes. Please go ahead, brother.
Okay. I have a question. I'm on 10 years route, family route. My 2 children are British, and the rest of 2, we are on 10 years route, and we have a second extension already,
Right.
2.5 year. We are taking benefits like house benefits and child benefit.
Yes.
But I want to apply for my mother from back home, Pakistan, for a visit visa.
Yes.
So I don't really know what to do, or if you can help me out, give me any advice, or what should I do?
Of course I can. And just to clarify your question, what specifically are you querying? So are you querying the requirements for a visit visa, or is it in light of the fact that you're on benefits, whether or not your financial circumstances can support a visit application?
I just want to make her a visit for maybe a couple of weeks or a month. But someone told me if we are on benefits, it's very difficult to sponsor someone for visiting, even your mother.
So in terms of visit visas, there are a number of things that the Home Office will look at. And one of the things that they will look at is the finances around this visit. And the reason why they look at that is because it demonstrates 2 things. Firstly, finances are indicative of a person's personal circumstances, and whether or not this visit is proportionate to those circumstances. And that then indicates to the Home Office whether or not this is a genuine visit. Is this person likely to go back? Because say, for example, an individual is earning £100 a week, but their visit is going to cost them, £150 or, or even £100. Why would they be spending that kind of money? Is it really proportionate to the aim, and are they likely to go back? And that's why finances are important, as well as the fact that you need to be able to afford the visit and not be a burden on the state once you get here, because you need to be able to financially provide for yourself, or the sponsor needs to provide for the applicant. Now, what the Home Office will look at is they will look at your financial circumstances, and they will also look at the financial circumstances of your mother, who you are wanting to invite. I don't know if your mum has any kind of income or any assets that she can use towards her own trip. But the Home Office will look at your income, and at the moment that's benefits. They will also look at any assets that you have and any savings that you have. And the purpose of that visit, and is it really affordable for you to have your mum come and visit? You say several weeks, but the visit visas are not restricted by what you say in terms of the duration of your trip. So you may be intending to come, or your mum may be intending to come for several weeks, but the visa will be granted for 6 months. And she can stay up to 6 months. She can get here and change her mind. She might come for 6 months and change her mind and stay for 6 weeks. But the Home Office is looking to see that somebody can afford a trip for the 6 months. And that's what you've got to assess when you're looking at your finances. Housing is not likely to be a problem because you pay for your house anyway. You just need to demonstrate that you've got sufficient space without it being overcrowded. So there's no additional cost in terms of housing. What's the purpose of the trip? What additional costs are associated with that? And are you able to afford it? And obviously you've got the flight, the visa fees and things of that nature. And so assess it in that context. Does this visit look affordable and proportionate to our circumstances when we present it to the Home Office?
So if my mother, if she get enough savings back home or property on her own name,
yes,
or my 2 brothers are there, if they sponsor her from back home,
yes,
then would be chances more high she might get visa for visit.
Yes, and again, it's about meeting those requirements. If she has assets in her own name in Pakistan. If she has family and she has sons who are working and supporting her, then there's an incentive for her to go back. She has things to go back to, so it looks more like a genuine visit. but also, you know, the financial requirement is met because there are people who can support that trip, and you might want to combine your resources. You know, they may pay for part of the trip and you may pay for the other part of the trip. So they may pay for the flight ticket and you may pay for, you know, the food and for her stay in the UK. So you can combine resources in that manner as well, and that increases the chances. But again, it comes back to proportionality. If, for example, your two brothers are working and the only money they have in terms of savings is the flight ticket, then is it really proportionate that they're going to spend all of their life savings to send your mum to the UK? And if they are spending all of their life savings to send your mum to the UK, then why are they? And that's where the Home Office starts questioning the intention behind somebody coming. You know, it's obviously quite important if you're spending your life savings. Is it important enough for that person to go back, or is it they'll get here and then they won't go back?
So how about if, say, for example, my mother, she, obviously my whole family is back home. Mm-hmm. So if she herself says, I have enough finances to manage my own expenses, I just want to visit us.
Yes.
And also, there is no restriction from the Home Office, we are taking housing benefits. So is this can cause for rejection, or this is not really Home Office concern?
There is not. Yeah, no, it's not. It's not Home Office concern. Obviously, it's a concern in the sense that they want to see what your means are. And it may be a concern in the sense that your landlord, whether that's a local authority, a housing association or private landlord, there may be a clause within your tenancy agreement that says, you know, you can't have somebody come and stay. So, but yeah, I mean, are people on benefits prevented from sponsoring somebody to come and visit them? No, they're not. So the fact that you're on benefits is not a bar to you sponsoring. It's the level of your income that they will look at. Okay. Does that answer your question?
Yeah.
That's lovely. Fine. Thank you so much, brother, for calling. Thank you.
Thank you. Assalamu alaikum.
Alaikum assalam wa rahmatullah. Wonderful. So moving on to some of the other questions that we have this evening. I will try and get through these and say as quickly as I can do because we do have quite a few waiting. We have a question. The sponsor of a wife and 3 children passed away. Family came here in the UK nearly 5 years ago. What is their situation regarding the right to stay? So I'm so sorry for the family's loss. With regards to the sponsor of the wife, I'm assuming that the wife came in on a spouse visa. You haven't provided that information in your question. And 3 dependent children. And again, I'm assuming that they're not British, that they came to the UK. With regards to staying in the UK, then there is a bereaved partner route. So if somebody's here on a spouse visa, and that visa does not have to be extant, that leave does not have to be, it could have expired, so it doesn't have to be extant at the date of application, then they can apply under a bereaved partner route, and that they would provide evidence of the relationship, that they were partners, so a marriage certificate, for example. For the children, there'll be birth certificates, you can put dependents on there, and any other evidence that's called for. So generally the Home Office is looking for, was there that relationship there in terms of the legal relationship, and then was the relationship subsisting? So were the couple living as husband and wife and intending to do so prior to death? So that's the way to present the application. So there is a route, and if that application is successful, the outcome of that is indefinite leave to remain in the United Kingdom. So you're looking at a bereaved partner route for settlement in the United Kingdom. So best of luck with that, and inshallah any follow-up questions, send them through. Again, moving on to another question, 2 questions that this individual has. I made my wife's entry clearance application 6 months ago, but no reply from the Home Office. I chased them by phone call for an update. They emailed me and said your application is under consideration. And what I will do, so the second part of that question, I will read out just after this short break. Inshallah, come back to join me then. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. We are now into the third segment of this show, so please do get your questions in if you do want them answered this evening. I'm going to jump straight into the questions because there are quite a few that are still outstanding, and I do want to get through as many of these as I can for you before the end of the show. So I did read out the first part of a question with regards to a brother who's waiting for his wife's application. It's a spouse application that's been pending for more than 6 months. The Home Office have indicated that it is under consideration. And my advice is you do simply need to wait. You know that the decision has not been made. You also know that it is under consideration and the Home Office haven't indicated they want any additional evidence. So my advice is wait a little bit longer. Many of you will know, and if you don't know, I will explain. The Home Office has recently confirmed that overseas applications, the times have extended from 12 weeks to 24 weeks for decisions, and that so priority can be given to the applications made by individuals from Ukraine who are fleeing the humanitarian crisis in that country. And so there are delays, and so this is not unusual that your application is taking longer. Be reassured by the fact that the Home Office has confirmed that the application is under consideration, and also be assured that if they do need anything further from you, you will be contacted. And unfortunately, that's the best I can advise you with regards to that. A similar question. So, Assalamu alaikum. My son applied for spouse visa. The Jerry service called my daughter-in-law in Pakistan to come and submit her passport, which she did 10 weeks ago. We did not hear anything from them since then. Can you please answer us how long we have to wait for the answer, and is there anything we can do? So again, exactly the same, unfortunately, up to 24 weeks for a decision. So if it's been 10 weeks, it may have been, I think this question came in last week, so you've got an additional week there. You've still got some way to go. You're about halfway through the waiting process, I'm afraid. Is there anything you can do there, apart from wait and pray? Unfortunately not. So inshallah, just, go with the process. And if there is anything else, that the Home Office will let you know. Next question is, I went to Pakistan in March this year. I had my nikah done over there with a Pakistani girl. I am a British citizen. What do I need to do to bring my wife to the UK, and what does she need to do? Do I apply from the UK, or does she apply from there? She's a doctor by profession. What does she need to do to work as a doctor in the UK? So several questions within that scenario. So with regards to this question, the brother got married in Pakistan and is wanting to know what he needs to do to bring his wife to the United Kingdom. So with regards to spouse applications, you need to make an application and you need to provide the documents that the immigration rules specify to support the application. What the Home Office expects to see, they need evidence that you are married, that you have met each other, and that this is a genuine and subsisting marriage and relationship. So your nikah nama, marriage certificate, if it's not in English, then it needs to be translated into English by an official translator. You will have any kind of contact details to show that the relationship is genuine and subsisting. There's a financial requirement, as you will know, so £18,600 per annum gross, and depending on how you earn your money, so whether it's salaried employment or self-employment, there are specified documents in terms of what you do need to provide to support your application. With regards to what your wife needs to do, then there are two things from Pakistan in addition to providing the other evidence. The first being the English language test from an approved provider at level A1. That's not to say that if her English isn't good, that she can't jump to a higher level. So if she's proficient in English, she might want to do the A2 or even the B1 level, which she will need for future applications, but the minimum requirement is an A1. The exception being that if she has studied a degree course, which she will have done for her qualification as a doctor, if her degree was taught in the English language, then again, that can meet the English requirement test without needing to take an additional approved provider test. And the second thing from Pakistan is a TB test, only valid for a short period of time, so 6 months. And so please do ensure that you do that once all the other evidence has been collated, not to start. Where is the application made? The application is made online. So that can be done from here or from Pakistan. And it is submitted online and paid for online as well. And then you book an appointment with a commercial partner, Jerry FedEx, for your wife to submit her documents and enroll her biometrics, and that would be done in Pakistan. You moved on to some other questions with regards to her qualification as a doctor and what she would need to do to work in the United Kingdom. Usually, overseas doctors are required to undertake some further training and testing in the United Kingdom. You may want to look up the PLAB test, that's PLAB test, and what she needs to do in respect of that. But that my understanding is that there is further training and theory exams that she would need to pass in order to continue practicing in the United Kingdom. But PLAB test is where to look, and you will be able to find some further details online as well. Moving on to another question. So, and again relating to immigration law. So my wife is on the 5-year spouse visa route. She came into the UK in March 2017. When can we apply for indefinite leave to remain, and what do we need? Now, with the spouse route, that's granted for a period, an initial period of 2.5 years. Or 33 months, and then an extension is then sought at that point, which I'm assuming you've now done because your wife's been in the United Kingdom for almost 5 years. When her second period of leave expires, you then make an application for indefinite leave to remain, and you would do that up to 28 days before her current leave expires. So whatever her biometric residence card has as her expiry date, look at that. And then up to 28 days before that, you can make the application. What do you need? So the Home Office are still wanting to see evidence that you are still married, and more importantly, that the relationship is still genuine and subsisting, that you do have an intention to remain married and to remain living together as husband and wife going forward. There is a financial requirement. So again, you are required to provide evidence of finances. It's the same requirement unless you have dependent children who are not British or settled. So if you have children and they're not British, then there's an increased financial requirement. But if it's just you and your wife, or if there are children and they're British and they're not going to be applying, then 18,600 gross per annum. That can be just your income. It could be a combination of your and your wife's income. So have a look at that. And then there is the specified evidence. So the Home Office, again, depending on how you receive your income. So is it self-employment? Is it employment? Is it a non-employment income? That the Home Office has specified evidence for each of those routes that you need to provide to satisfy them. There's an accommodation requirement, and there is an English language requirement as well. So look at those, and they're the documents that you would need to provide. Again, it's an online application that you would need to make online and pay for online, and then supply the supporting documents. So I hope that answers your question. But the main question was when to apply, and that's up to 28 days before the current leave expires. This question, the next one, is quite a lengthy question. So I'll try and break it down as much as I can do. So I came into this country in 2005 as a spouse for 2 years. But in that 2 years, I faced domestic abuse, and I'm assuming you mean then that the marriage broke down. After that, I lived in this country until 2014. So I read into that once your visa expired after the 2 years, there was no further lawful residence up until 2014. But I always applied in that period, but the Home Office refused again and again. So that confirms that you had no lawful residence. But in 2014, I received my stay. But in this situation, the Home Office said you apply for your nationality in 2019. But the Home Office rejected my application because they said applying in 2024. Hope I explained this well. I have understood the gist of your question. And I will summarize it as follows. So you entered the United Kingdom in 2005. And that at that time, that would have been granted for 2 years. And then you would have been eligible to apply for your indefinite leave to remain. The marriage then broke down within that 2-year period, resulting in you then living in the United Kingdom unlawfully, essentially without any kind of leave as an overstayer, up until 2014. In that period, you did try to regularise your status, but those applications were rejected by the Home Office. You then regularised your status in 2014, and you don't say in what category, and I'm not really sure that's particularly relevant here. And then you made an application for naturalisation to become a British citizen in 2019, but this was rejected. And the Home Office have advised you that you need to wait until 2024 before you apply again. So that's my understanding of your question. And so you're essentially asking is, are the Home Office providing you with the correct advice? And essentially, what this comes round to is the suitability provisions within naturalisation and citizenship applications. And a lot of people find these quite confusing and fall foul of these, because they are quite different to the rules in respect of the suitability rules within the immigration rules. The nationality ones can be stricter. We are going to our final break for this evening. Please join me after the break and I will continue to provide you with guidance in respect of that question. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. We've now entered the final segment of this show, and inshallah I will continue to answer your questions. Just before we went to the break, I was picking up on a question in relation to nationality law and the suitability criteria. We heard from the questioner that their application for citizenship had been refused because they had made an application in 2019 after being advised by the Home Office to do so, for the Home Office to say now that they needed to wait until 2024. That the advice from the Home Office is the correct advice. So if you've had a period of breaches or criteria that falls foul of the suitability requirements, such as overstaying, criminal convictions, then the Home Office do expect you to wait 10 years before that application is made. Because your status was regularised in 2014, and prior to that you had had a prolonged period of overstaying, then I would expect the Home Office to say, wait the 10 years, so 2024 would be the right time to make that application, and that is the correct information this time from the Home Office. Why, unfortunately, you were previously advised November 2019, I'm not entirely sure. But I would repeat your application in 2024, and then you do have a higher chance of succeeding in that. We do have a caller on the line, so inshallah I will proceed to take that call. Hello, assalamu alaikum. Hello, assalamu alaikum.
Assalamu alaikum, sir. Can you hear me?
Oh, wa alaikum assalam. Yes, I can.
Oh, that's great. Thank you very much. I've got a couple of questions actually. Me and my wife, we are expecting a baby in next month's time, and we would like to invite my mother-in-law. She's in Pakistan at the moment, and my question is that do we need to send her an invitation letter, or will we be sending her a sponsorship for the visa? So I'm not clear what's the best course of action to take to invite her to visit us for the occasion of we're having a baby, so that she can be here for that occasion. So I was wondering if you can kindly guide me on that, please.
I can do. And you said you had a couple of questions. What's your other question?
Oh yeah, sure. And the next question is that if obviously at the moment she probably be visiting us for probably a couple of months, but we were thinking to apply when she can she apply for a longer visa, like 5 years or 10 years one, and if we do that, does she need sort of a visit before, like visa before she has visited? Like she came to UK in early 90s.
Yeah.
She had the visa before, but I mean, my question is whether when someone applies for a longer visa, like a 5-year or 10-year one, do they need to have? Is there a prerequisite to have a visa before? Like a visit visa for a couple of 6 months, or I don't know, a year visa on the passport.
Yeah.
For a longer one.
Yeah.
That's
yeah. So in terms of your first question, so congratulations on the baby news,
so
and inshallah, best of luck with that. Your line wasn't completely clear, so I'll just. Is it your mother-in-law you said you wanted to invite?
That's right. Yeah.
Perfect. So with regards to what you need to send, you don't really need to send anything. You don't have to formally invite or send a form to your mother-in-law. You would just make the application and you would write a covering letter. Your mother-in-law can write it, you can write it. Whoever wants to write the letter, there can be a covering letter explaining the purpose of the visit. Why is she coming? How long is she coming for? And
right.
The purpose behind that. And then provide the supporting evidence. Your mother-in-law's coming to help your wife with a new baby, to meet the grandchild. Provide the evidence that you are expecting a baby, the baby's due date. And again, you may have heard the answer I provided to an earlier question with regards to finances and the requirements around the immigration rules. And again, they would very much apply here. You still have to persuade the Home Office that your mother-in-law will go back after this visit. And there are incentives to do that. With regards to your second question, usually, I mean, there isn't necessarily any guidance that says you must have held a visa prior. You must have held a 6-month visa or a 12-month visa prior to applying for a longer-term visa. You can immediately apply for a long-term visa, the 2 years or the 5 years. But they are harder to come by. And if you have a previous period of compliance, so if you've come on a 6-month visa, gone back, done that several times, then the chances of your long-term visa being successful, unless your circumstances are quite persuasive and they grant it outright, then previous compliance can always assist with that application as well.
Right.
Okay.
That's great. You answered both my questions. Thank you very much for
my absolute pleasure.
Those two.
Thank you for calling. Thank you.
Take care. Assalamu alaikum.
Alaikum assalam wa rahmatullah. So another visit visa question in relation to immigration rules. I do understand that we do have another caller on the line, and inshallah we'll take that call. Hello, assalamu alaikum. Assalamu alaikum.
Assalamu alaikum.
Alaikum assalam.
Sister, I wanted to ask you a question about a property.
Yeah, please go ahead.
What it is I'm trying to transfer a name from I bought a house jointly with my mother.
Okay.
And it was bought from the council. And this, I don't know if you know any situation with the right to buy.
So is that how the property was purchased, on the right to buy?
And the right to buy from the council, yes.
Yeah.
it hasn't been 10 years. I don't know if you're aware. I don't know if we're trying to transfer the name of my mom into my name.
Okay.
I'm just wondering, is that possible to do that? Because I've been told something about a restriction that you can't do in the first 10 years.
Okay.
I don't know whether you know anything about that.
I don't, and it probably varies from property to property. Have you got a copy of the title deeds?
Yes.
Okay, and have you read the title deeds?
Yes, I have read it briefly, yes.
Okay, and is there a covenant within those title deeds that say you cannot transfer the property to another name within 10 years of you acquiring it?
There's something that it mentions that there's some sort of restriction and you need some sort of certificate from the council, and I don't know how to go around that.
Okay, so it sounds like there is a covenant on there that prevents that property being transferred. It's not an area that I specialise in, and so I always add the caveat with those to get independent legal advice before you take any steps. And I think that's what you would be best advised to do. In terms of getting permission from the council, you would contact their property department or their legal team at your local council and explain what it is that you're wanting to do. But I certainly would suggest seeking independent legal advice before that, because there are ways of removing covenants from title deeds. But I wouldn't want to kind of jeopardise your legal position by suggesting that you immediately contact the council and ask that to be removed.
So what do you suggest I do, sister? What's the best way of going around this?
There's two ways. I mean, what you can do is contact a property law specialist, and there's plenty of them around. Most of them offer you, free 15 minutes or free half an hour advice, and ask them that question. Explain that there's a restrictive covenant on your deeds, that you are wanting to transfer the property, but you are within that period where you are restricted. How do you go about it? How do you go about removing the restriction? And if it can't be removed, how do you get the permission required from the council? And they will be able to then guide you about any consequences that may come with. Does that answer your question?
Jazakallah, sister. Thank you.
Barakallah feek. Thank you so much. Thank you. Right. So with regards to this evening, so I do have another question, and I'm disappointed that we don't have a lot of time left for this evening, but I do want to touch upon this. So it's in relation to an employer. Again, immigration law rights. I'd like to apply for an employer sponsor license. My business is in opticians. What are the requirements for an employer to meet in order to qualify for a license? And what does it have? What does it have to offer to the applicant? So with regards to, it's a full show in itself in respect of sponsor licenses and the requirements, because they are quite broad. Opticians, you're looking for skilled workers. And you might want to check whether your profession falls into a shortage occupation. So there's a shortage occupation list. Again, you'll find that if you put the shortage occupation list into a search engine, or if you go onto the Home Office guidance pages, you will find information on the shortage occupation list there. What are the requirements for sponsor licenses? Well, you need one to employ anybody from outside of the United Kingdom, so any overseas workers, and that now includes European workers, workers from Norway and Sweden and so forth as well. So you have a broad category there. And there are quite vast requirements in terms of sponsor licenses. So the first is that you would need a license. You would also need to have a sponsor license management system. And it's really important that you have that in place. You also need several key workers and personnel in place who are going to then manage this system. Some of those duties you can delegate. So you may have a legal representative who can manage some of those for you. But there are some that you do need to manage yourself and be responsible for those. And in terms of what you need, unfortunately, it varies from category to category. And as I say, we don't have the time today to do that. There are pay scales for what you need to offer the applicant. You do obviously need to offer them a job, but there are pay scales at which you need to offer that job. It's different if your profession is on the shortage occupation list, because then you can offer a lower salary. It's a percentage of the full salary that you would offer otherwise. But there are different types of sponsor licenses also. So there are those who are for skilled workers, which is what you're looking for. But there's also licenses for people wanting to employ temporary workers on a much shorter time frame. So just kind of a brief overview there. Main thing is to look at the management requirements, the personnel requirements, and then do you have the documentary evidence to support your application? Because the Home Office needs to be satisfied that you do need this personnel, there is legitimate employment, and that it will be efficiently managed and properly managed in terms of those duties that you have, and those duties can be quite vast. So you will need advice there as well. Thank you so much for everybody who has participated in the show today. We are now coming to the end of today's show. Inshallah, join me again next Monday from 7 p.m. Assalamu alaikum wa rahmatullahi wa barakatuh.